Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the failure to address payroll when dealing with termination and severance pay. So all too often what happens is when somebody gets fired or terminated from their job, or even when they quit their job to a lesser degree, they look solely at termination pay in lieu of notice and severance pay. And this is the same thing applies even with respect to lawyers. Their focus is on those two aspects. However, those two aspects are not by themselves the only thing that should be addressed. First of all, termination pay is a very standardized calculation, with the exception of how payroll is properly done. There's only a minimal fluctuation oftentimes with respect to termination pay in lieu of notice that can be fought over. Severance pay, for financial economic reasons, are difficult to fight and long drawn out, and the employers know this because they are based on common law precedent, which takes into account a lot of factors and have to be dealt with. That tends to be the focus of most people when they're terminated or fired. What instead also should be addressed is the aspect of payroll. And we're talking about payroll for the entirety of one's employment, because as my other videos have talked about, and what you see is that payroll is not looked at enough. And there are lots of issues with respect to payroll, much of it depending on the province within which you're working. Because in particular in Canada, as I've said before, there are at least 15 different systems for calculating payroll. And when you have so many different systems, and where the tendency is not even use a Canadian system for calculating payroll, you have a serious issue. I cannot overstate the importance of payroll with respect to dealing with a termination, a firing, or even quitting one's job. Because especially for long-serving employees, in particular provinces, the amount of back pay that's discernible when you actually do a proper appraisal as the payroll of the company can be extremely significant. And not only that, since payroll is determined most often by statute, it is not subject to the vagaries of common law and the broader interpretation that one finds when it comes to severance pay. Because severance pay is based on a series of factors that can be weighed and judged differently based on different circumstances. Instead, payroll is determined by the exact application of the statute, the employment standards legislation that governs that particular jurisdiction, typically provincial, but in some cases Canada Labor Code. And it is that law and those calculations would dictate, and based on our own experience, it is all too often not being followed. And if you're able to establish, number one, that payroll isn't being calculated, you have leverage. And you can use that leverage to attain strength to deal with severance pay, to deal with other circumstances related to the end of your employment. Because leverage is critical, both from your own perspective and from the perspective of your lawyer. So you need somebody who's really a payroll lawyer in addition to being a termination and severance pay lawyer. Because they can then deal with this stuff. They can ascertain whether payroll is a core issue. And when it is a core issue, and when there's considerable money involved, this is statutory money. It's not subject to as much discrepancy as common law money, such as severance pay or human rights violations, unjust enrichment, and all those different matters. What you're looking at is statutory failings. And it gives you another leverage point that we use a lot ourselves. And that is the ability to bring this up as class action litigation, which is more beneficial to the employee from the standpoint of cost, because the lawyer then has the ability to go after the company with respect to all the employees who have been offset by the improper practices of payroll. And that is critical to understand, because these are fights that are becoming more common, and they are fights that the employers cannot afford to lose, or at least they believe they cannot afford to lose because it sets a bad precedent. So instead of setting a bad precedent, what lawyers such as myself do is you take on the entire company in one fell swoop, and it makes it extremely challenging for those companies because then they're on the hook for everything. And as such, it's important that you are looking beyond termination pay in lieu of notice, beyond severance pay, and actually having payroll addressed and having a lawyer who understands the importance of payroll to the end of one's employment, because the law was designed to protect the employees. They understand the imbalance that exists between employer and employee, and even the statutes very often provided protections with respect to payroll and the failure to pay fully payroll. And that is something that you have to be aware of, your lawyer should be dealing with, and should be addressing. Because as I say in many of these videos, this is earned money that you're entitled to. Thank you.